Well, hello there, and welcome to another edition of the Employment Law Show. We're ready to go. John Scholes here, and of course, Lior Samfiru, employment lawyer at employmentlawyer.ca. Always reach out to Lior for that conversation. Don't sit in wonder, panicking if you've just been let go or dealing with an employer. Talking about severance, it could be anything under what we talk about weekly here in the show. The number, 1-855-821-5900. Help at employmentlawyer.ca. I'll give you a website right off the top. We're going to talk about it and use it during the next half hour. That is pocketemploymentlawyer.ca. We will get to some phone calls from one of our long-running radio shows across the country. You can always tune in. Go to employmentlawyer.ca for more details on finding a radio station near you. And always encouraged to call in, whether it's a half-hour show during the week or hour-longs on the weekend. We'd like to have you on board for that. You might, your voice might be on the show in the future for sure. Main topic today, employee misclassification. What is it? I don't know. We'll talk about it in another segment going forward here in just a few minutes. But Lior, we always talk about the week that was, or, a case of the day. What do you got going on this week, pal?
John, great to be here, of course, to talk about this very, very important topic. We all have to know our employment law rights. We may not have to know our rights when it comes to other things, but when it comes to employment law, you have to know the rights. There's no other options. If you have a job, you need to know what to do if you're being mistreated, if your company is doing something they're not supposed to do, if you lost your job, if your job changes. All those things happen. They happen often. And if you don't know your rights, you may accidentally give them away. You may not act when you're supposed to. You may walk away from entitlements that you have. Well, not if you watch this show. On this show, we'll tell you what you need to know. We'll inform you. We'll educate you. We'll empower you with the knowledge of law. So if you're always wondered about what to do, and if something going on is legal, you don't have to wonder anymore. We'll tell you everything you need to know and much more on the show. Of course, this is a 30-minute show. Beyond the show, as John said, you can reach me in the office, my team and I. We can help you. We can have that private conversation. But right now, you can learn a lot. And as John said, I always like to start off with the situation that came across my desk just over the past few days. I spoke with a gentleman who had worked for the same employer as a truck driver, worked for about 10 years or so. Well, very recently, he had noticed that his truck was unsafe. Not a technical person myself, so I don't necessarily understand the technicalities, but it was unsafe. He felt that it wouldn't meet safety inspections. It wasn't really road-worthy. So he told his employer, you got to do something about this truck. I don't want to continue driving it. I don't think it's safe. It puts me and others in danger. Well, his employer told him, we got it, no problem. We'll deal with that, but for now, please do your load today. We'll deal with that next time, but we need you to do the load. He said, okay, no problem, I'll do that. He wasn't crazy about it, but he did. He went, he drove the truck, got back safely, thankfully. The next day, same thing happens. He goes back to work, still nothing is done. He tells his employer, you have to deal with this. I'm not going to drive this again. It's not safe. His employer says, okay, well, go home. We'll call you back to work when this is all resolved. Well, fast forward a couple of days, a week, 2 weeks, nothing is done. He calls his employer. He's being ghosted now. They don't go back to him. They don't schedule him to work. As far as he knows, nothing happens with this truck. So he does the right thing, the smart thing. He calls me. He wants to understand his rights. So here's the thing. Workplace safety, one of the most important things that there is. You should always work in a safe work environment. There's no exceptions to that. You also have the right to refuse unsafe work. When you refuse unsafe work, you can't be punished for that. Your employer can't discipline you, cut your pay, do anything to you. They have to fix the problem, or if they disagree that there is a problem, they have to bring in an inspector from the government, from the Ministry of Labor, who will decide what's what. But that's what they have to do. They didn't do that here. They didn't fix the problem. They didn't call in anyone from the Ministry of Labor, and they stopped scheduling this guy. They punished him for complaining about unsafe work. Illegal. We call this reprisal. He was punished for standing up for his rights. So he's dealing with a breach of employment standards, a breach of occupational health and safety. This is also a wrongful dismissal. It's all those things. I'm going to help him resolve it. But I wanted to remind everyone out there, you can and you should, you must refuse unsafe work. You can't be punished. If anything happens to you in that situation, call me. The law's going to take that very, very seriously.
You got to think what would have happened to this guy if he went out on the road the second or third day without having this truck fixed and he got into an accident. He got hurt. I mean, the liability for this company would have been massive, right?
Yeah, and there's nothing that's worth that. So this is a big deal. That's why we don't mess around when it comes to safety. You have to do what you have to do as an employer. And in this case, they didn't. And that's why I say, there's no exceptions. Oftentimes there's exceptions, there's strategies when it comes to the law, not when it comes to safety. If something's unsafe, even if you're not sure, don't work. Don't put yourself and others in danger. Let your employer deal with that as they have to. If you don't do that, you will certainly regret it later.
So advising the employer going forward, if this ever happened again or for a different employer, what should they have done by second day, saying, get out of the truck, we'll replace it, take a day off, do whatever you got to do?
Yes, deal with it, fix the truck. And if they think it is safe and this employee is still refusing to work, bring in an inspector. They do this for a living. They'll come in the same day. That person will inspect. If the truck is safe, fantastic. If it's not safe, they'll figure out what needs to be done to fix it. What you can't do is punish this employee, ghost them, not schedule them for work because you don't want to fix an unsafe truck.
Again, a way to reach out to Lior and the team, employmentlawyer.ca, always a good one. And as I mentioned off the top, you catch our radio shows during the week. We'd love to have you come on board, make the phone calls, ask the questions. I want to go to our first phone call, Lior, from one of our shows right now. Let's listen up.
I've just been let go from a job. I worked for the company for a year and a half. I was making $120 a year. It was an engineering job. They've offered me 1 month severance pay.
About how old are you?
56.
A lot of people think that's great.
Well, John, if we were taking a poll, right? If we were asking folks, this guy worked for a year and he was offered 1 month's pay. So he was offered a month per year. Is that good or not? John, 95% of people, unless they watch the show, but 95% of people will say, oh yeah, that's great. He was offered a month for the year that he worked. That's a fantastic severance offer. Guess what? It's not. It is, in fact, a terrible severance offer. I want you to remember that a short service employee is treated disproportionately better than a long service employee when it comes to severance. So if you work for a few months, a year, a couple of years, that severance that you're going to get is going to be significant. It's going to be measured in months. So this guy's offer, not good, not even close. Well, rather than me just telling you how much severance he's owed, I'm going to show you how you can find out for yourself. We're going to use our severance calculator tool. You find that, of course, at pocketemploymentlawyer.ca. Let's go there right now. Let's plug in the information and let's see how much severance this person should actually be getting. So we know that this person is 56 years of age, is an engineer, had been there for just about a year, was offered 1 month's pay. Well, no. You see right there at the bottom that he's owed right around 6 months' pay. Yes, 6 months, even though he only worked there for a year. That's how short service employees are treated when it comes to severance, and that's how easy it is for you to find out yourself. Just go to pocketemploymentlawyer.ca. It's free and anonymous, and in seconds, you can get an assessment of how much you or someone that you know is owed when it comes to severance.
What could have changed that, maybe for better even or for worse? Would that be the employment contract? Would that have changed things possibly?
So with a properly drafted employment contract, that employer could have limited severance to as little as 2 weeks. Forget about 6 months, it could have been 2 weeks. But unless there's an employment agreement that's drafted in a very specific way and it says certain things in a certain sequence, then he gets his full severance, which for him, 6 months pay. Big, big difference.
Phone call number 2. We always do 2, maybe 3 a show. Let's get to that second one now. Have a listen.
Question. I've been working what they call permanent part-time for a company for the last almost 3 years now. We've always averaged between 45 and 50 hours a week. Suddenly, they've cut us down to like 12 hours a week.
Have you ever been cut down to 12 hours per week before?
Never.
So this is going to be a significant reduction in pay.
Considerably. I can't afford to work there at this point.
Yeah, that's a big change. That's a huge change.
It's massive. It's a huge, huge reduction. So let's be very clear. An employer does not have a right to make such a significant change in pay. That is massive. To go from 45 hours to get paid for that to 12 hours, no. So what this means is this employee can now consider their employment as terminated. We call this, of course, constructive dismissal. It happens when your employer makes a significant change and you don't accept that change. So he can consider his employment as terminated and get his full severance. That is much better to do than to continue working at 12 hours a week. If he continues working at 12 hours a week, not only is he making less money, but now he's given the company the right to do it again. And when they reduce him from 12 hours to 3 hours, he won't be able to do anything because he let it happen that first time. Same with you at home. If your employer makes significant changes, whether it's changes in pay, in hour, changes your shifts, your responsibilities, you may be able to say constructive dismissal. Not okay with this, not going to accept that. I'm going to consider my employment as being terminated. Of course, before you walk out of your employer and say, that's it, I'm gone, I want you to call me. We have to do this correctly, but remember, constructive dismissal.
Is there a small little bit of leeway? Is there a threshold for an employer if you went from 45 down to 42 hours a week? Is that allowable?
So there's a bit of a leeway, yes.
Okay.
So anywhere 10 to 12-ish% a change or reduction, an employer may be able to get away with. When it comes to anything in that range, perhaps. Anything over that, now we're in constructive dismissal territory for this person to go from 45 to 12. That's not even close.
We got to employee misclassification. What is it? We'll get to that on the other side of the break, and our third phone call is coming up, so stay with us. In the meantime, always reach out to Lior, as you should be, 1-855-821-5900, help@employmentlawyer.ca. Double up that email. Coming right back. Stay with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back, Employment Law Show. We're standing now. Just get a little exercise. I mentioned 3 phone calls on the main topic. We do that every week, and it's going to be employee misclassification. That is coming up momentarily. Always a learning opportunity, so that's why you watch this show every week for, it's just 30 minutes. So join us anytime, by the way, through phone. Get a hold of Lior and his team, 1-855-821-5900. Back that up with an email, help@employmentlawyer.ca. Let's get to that third phone call and have a listen.
We've got a daughter who is in her first real job coming out of university. She's coming up to a year at the firm. It's a sort of a sales environment, and she was one of 12 or 14 people in the sort of the training group. There's one left. It's her, and the environment's become very difficult, very toxic. And she says, "There's not really much on the table here. Why don't I just leave? What have I got to lose?" But then I'm thinking there might be more on the table too if she walks away, even though it's only been a year with the firm.
Pretty stressful first gig out of university, right?
Yeah, what a bad way to start your working life.
Yeah.
Certainly not a good thing at all. But let's talk about what this means. Of course, everyone has a right to work in a supportive work environment and an environment that's not polluted with harassment and bullying, etc. So if this is a toxic work environment, her employer must fix it. They have to deal with it. They cannot ignore it. So what I always say in this situation, tell your employer, whoever the right person there is, the HR person, the manager, whoever the right person is, let them know in writing what you're faced with, what you're dealing with about this toxic work environment. They have to investigate and they have to fix that problem. If they ignore it, they don't fix it, they don't care, they don't try, they don't do anything, well, that could easily be a constructive dismissal. It could be another cause of action as well. You have an obligation to do that. The key is to give your employer the chance to fix this. If they don't, she can then still leave, but with compensation, with severance. If she just walks away now, she doesn't get anything. Same with you at home. If you're a victim of workplace harassment, bullying, a toxic work environment, tell your employer. Keep a record of what's happened. You always want to have the ability to prove what's been happening to you. The person that's mistreating you is not going to admit that. So have that proof, talk to your employer, and if nothing works, call me and let me deal with it.
The question I always throw at you, that when you're the one that's coming up, what happens if it's the boss at the top doing it? Where do you go, right?
Oh, it's the owner of the company that's the root of the problem. Who are you going to talk to, right? There's no other option. Well, if you cannot deal with it internally, there's no way to deal with it, then that's when I deal with it externally. You still need to have that proof, whether it's something in writing, whether it's a witness, whether it's a recording, some proof. But if you have that proof, we can still get you out of there with compensation, with full severance, and potentially other damages. The key is to be able to prove that you're being mistreated.
Let's get on to our main topic, as mentioned off the top, employee misclassification. What is it? What does it mean to be an employee that's been misclassified, Lior?
So generally speaking, if you work somewhere, you can be an employee or a contractor. The key to remember is that you don't decide if you're an employee or a contractor. The company that you work for doesn't decide that. The law decides that based on certain criteria, which we'll get into. So if you really are an employee, but the company that you work for considers you, calls you a contractor, then you've been misclassified. So very often, many people that believe that they're actually contractors are not. They're employees, and they've been misclassified as a contractor. It doesn't matter what you call yourself. It doesn't matter what piece of paper you sign. It doesn't even matter how you pay your taxes. If you have a regular job, you go into work, you do your job, you go back the next day, you do the same thing. You are an employee, full stop. And if you've been misclassified, that could create problems with CRA, with employment laws, and that's what we want to talk about.
So you've been misclassified as a contractor. How do you know if that's happened? What are some of the key signs?
So a contractor is someone that's in business for him or herself. So if you're essentially running a business with clients, you have people that you do work for, then yes, you're likely a contractor. If you work with this company one day, another company another day, and you're looking for other clients, you're in business for yourself. Means, yeah, you're a contractor. None of these companies are necessarily your employer. On the other hand, if you work for one company, they tell you what to do, they tell you where to go, they decide your hours, you're an employee. It's as simple as that. It's almost never the case that you can be a contractor if you only work exclusively for one company. So if you work for one company, if they decide what you do, you are their employee. You've been misclassified. So always ask yourself, are you in business for yourself, in which case you're a contractor, or do you work for a company, in which case you're an employee?
So if it's such a big misstep, why do employers do it?
Because it's much cheaper to have a contractor than it is an employee, okay? You don't have to comply with minimum wage laws. You don't have to pay vacation pay. You don't have to pay overtime pay. You don't have to pay severance. So an employer thinks, wait a second, what a great idea. Let's just call someone a contractor and we could just save a bunch of money. The thing is, of course, John, you know this, the law is smarter than that. If it was that easy, everyone would be a contractor. It doesn't matter where you work for fast food, factory, office, everyone would just be contractors. Doesn't work that way. The law decides that, and if you've been misclassified and you're called a contractor when you're really an employee, there could be real consequences to that company.
Well, near in the middle there, you mentioned the severance part of it. Do they still get severance if they're misclassified?
Well, that's often when these issues come up. Someone is let go from their job. The company says, hey, you're a contractor. We don't have to pay you severance because you're not an employee. But not so fast. If that person was misclassified, they were really an employee, well, guess what? Of course they get severance. That severance can be as much as 2 years' pay. Every single day I get contacted by people that lost their jobs that are not paid any severance because they're supposedly contractors. Not true. If you lost your job, you're probably an employee. Doesn't matter what the company that you work for says. And again, you're owed severance. That could be quite significant.
This could have gone on for years, if not decades, when somebody or an employer realizes it. Now they're in for a big severance package, right?
I've spoken with several people over the years that have worked for a company for 20, even 30 years, supposedly as contractors. One person was a bookkeeper, worked for the same company for 30 years, was let go, was given nothing. They were owed 2 years' pay.
Wow.
Spoiler alert, you cannot work for a company for 20 plus years and be a contractor. You are an employee.
So you've been listening or watching talk about this for the last 5 or 6 minutes, Lior. You're thinking, okay, how do I know? I think I might be a contractor. Is there a way to find out?
Well, one of the ways, you can call me, but there's another way. We talked about pocketemploymentlawyer.ca. Again, it's pocketemploymentlawyer.ca. We have an independent contractor tool that you click on it, you answer a few questions, and it's going to give you an assessment as to whether you really are an employee or you're a contractor. Have you been misclassified? So you have to keep that in mind. You don't want to be working in a situation where you've been misclassified. There could be consequences for you as well if you're not paying your taxes properly, etc. So you have to be smart about it.
Again, that's pocketemploymentlawyer.ca. Write it down. Check it out. Go online and do it now. We'll take a short break. Get back to more of your questions and emails on the other side. And always to reach Lior, make that phone call, 1-855-821-5900, help@employmentlawyer.ca. Back it up with that email, and we're coming right back. Stay with us.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back. Employment Law Show. Good to go for a few more minutes here. You're always sending us your questions. We really appreciate that. A good way to do that is terminationquestions.com. Free website, terminationquestions.com. Even if it does not appear in this show, they get answered all the time. Lior's staff is really good about that. Here was the first one for the show today. I was just let go from my job without cause after 12 years in a supervisor position. I'm in my mid-40s and make over $80K. The employer is only offering 2 months termination pay and insists that this is due to business slowing down. Can they be forced into providing me a valid reason for dismissal? Can I pursue a wrongful dismissal? What do you think, Tom?
So there's a few things we need to talk about here. Let's start with the fact that business, whether the business is slow, bad business, slow business, does not change your entitlements. An employer does not get a break just because the business is struggling financially. When it comes to severance, if the company is doing amazing or if they're really struggling, does not change how much severance they have to pay. You may like that, you may think it's fair, you may think it's not fair, but that's the law. It's as simple as that. Now, when it comes to reasons, an employer is not required to give a reason when they let someone go with severance, okay? So there's no legal obligation to say, here's why we're letting you go. And I'll take it a step further. If an employer gives a reason, there's actually no legal obligation to make that the real reason. Listen, no one should ever lie, and there's ethical and moral reasons why an employer, of course, should not lie. But from a legal standpoint, if your employer tells you it's a restructuring, but it's not, they can do that so long as they pay proper severance. So in this case, it's not so much about the reason the company gives. It's not really about whether or not they're struggling or not. It's about whether this person is owed more than 2 months severance after 12 years of employment. Of course they're owed more. They're probably owed a year's pay. So this is a wrongful dismissal. It's a wrongful dismissal not because of the reason the company gave. It's a wrongful dismissal because this person is owed much more severance. So yes, they can pursue a wrongful dismissal claim, and they would be very successful and very easily because they're owed much more than 8 weeks.
Yeah, a slowdown doesn't qualify. If it's a bankruptcy, that might be different, right?
I was telling someone earlier today that the bankruptcy is kind of the kiss of death when it comes to employment law rights. If a company is actually in formal bankruptcy proceedings, that means employees may not get anywhere near what they're actually owed.
You can also reach out to Lior and join the conversation through the live stream on Facebook, LinkedIn, YouTube, at stlawyers.ca, at stlawyers.ca. Here's one for the show. Lior says, earlier this year, my manager claimed my performance was in question and said I'd received a verbal warning, but that never happened. I was placed on a performance improvement plan that was extended twice, with disciplinary hearings in between. Ultimately, I was dismissed for cause. Is this worth fighting, or did I forfeit my rights by going along with everything?
Well, it's an interesting question. I'll start by saying that it's extremely difficult for a company to let an employee go for cause. It's not enough to show that the employee did something wrong or even that the employee was disciplined. In order for there to be a termination for cause, that employee would have had to do something very bad, usually repeatedly, and then maybe after a while the company can say, hey, what more can we do with this bad employee? We can let them go for cause. Very difficult. And usually companies pull the trigger on a termination for cause well before they should. Now, I don't know exactly what this person did. It's certainly not a good idea to pretend that everything's okay if you're being disciplined, if you don't agree with that discipline, if you're put on a performance improvement plan. If you don't agree with it, say so. Tell your employer, I don't agree, and here's why. By doing that, you're going to make it that much more difficult to be terminated for cause. But ultimately, just based on how these things work, it's still very likely that this person is owed their full severance. Very difficult to terminate for cause. Unless you did something like you stole, you hit somebody, you were warned many times and you kept doing bad things. In those situations, yes, maybe you can be let go for cause and not get severance. In most other situations, even if you've done something wrong, severance is still owed.
When it comes to that performance improvement plan, they always ask to sign it. Does that mean you're agreeing with it, or are you just acknowledging that you received it? Because a lot of people, that's where they draw a line. I don't want to sign this thing.
Yeah.
Right?
Yeah. And you have to read that document, because usually what I would say is by signing here, you agree or acknowledge that we gave you a copy, that we told you about this, in which case it's okay to sign it. Because you're not agreeing that this is correct. You're just agreeing that you know about it, that they gave it to you. Now, on the other hand, if it says, by signing this, you agree that all of this is correct, you cannot sign that, not at all, unless you do agree with it. So you read that. But if it's just an acknowledgement that you received it, it's absolutely fine to sign.
And it does eventually amount to cause unless you go, right? If there's enough, it's done enough times.
If your employer has built up their case, they gave you a warning, another warning, a final warning, and you kept doing something, yes, of course they're going to be able to allege cause. But John, in my experience, most employers skip steps in the process. They don't do it properly, and they lose the ability to terminate for cause.
All right, we wrap up the show every week by putting Lior in the hot seat called Employment Rights Rapid Fire. Let's get into that right now. Okay, Lior, here we go. First one. Can your probation period be extended past 3 months?
Well, it's an interesting question. It can, but it's pointless. And what I mean by that is you can only be let go without severance in the first 3 months of employment. So beyond that, you really, even if you're on probation, it doesn't do anything. It doesn't mean anything. So people get very upset that their probation has been extended. It doesn't really do anything. I wouldn't worry about it. So as a practical matter, nothing happens to you if your probation gets extended.
Because we've heard 6 and 9 months before. It makes people panic, right?
Yeah, or it's 3 and now they say, well, we're not sure, so we're going to extend it to 4, 5, or 6. Don't worry about it. If they let you go at that point, they'll have to still pay your full entitlements, because it's only that first 3 months that allows the company maybe to let you go without compensation.
Next question. Can your employer put you on an unpaid suspension? Unpaid.
So for most people in a non-union environment, no, an employer does not have a right to put you on an unpaid suspension. Now, a paid suspension in some situations is possible, and an unpaid suspension, usually not legal. It's considered a constructive dismissal. Now, if it's a day, 2 days, you may not do anything about it. But if it's something more extended than that, you don't have to accept it. You don't want to accept it, and that could easily be a constructive dismissal.
For our third question, it all trickles back to the old severance package. Should a bonus also be factored into that package?
Yes, so your severance must include all components of your compensation: salary, benefits, bonus, car allowance. So yes, bonus has to be included. So if you usually get a bonus, it has to be included as part of your severance, not just your base salary. So it's not just how many months you get, it's also what's included in it.
Listen to this, employers. Your next question: is your employer permitted to reduce your salary as a disciplinary measure?
No. Generally speaking, that's not a legitimate disciplinary measure. Your employer cannot reduce your pay. If they do, again, as long as it's more than, say, 10 or 12%, that is a constructive dismissal, even if you've done something wrong, not something an employer should do.
Another rapid-fire question. Should you resign over unpaid wages?
Well, that's an interesting question to answer. So let me answer it this way. An employer, of course, has to pay you your wages. If they don't, that could be a constructive dismissal. That could be something that you can go to the Ministry of Labor for. It's a big deal. The most fundamental obligation an employer has is to pay you for your wages. So even if you're resigning, you can still say, I'm only resigning because of this. I have to get my full severance. So don't resign, though, without talking to me first. We want to do it in a way that allows you to get your severance.
And finally, can your employer place you on working notice?
Yes, an employer can't place you on working notice. That counts towards your severance, but the key is to make sure you got enough notice.
And that is it. We got it all in. Reach out to Lior, 1-855-821-5900, employmentlawyer.ca. And we'll catch you next time on the Employment Law Show.